Hi, and welcome to Visibility Unlimited and Visibility Unlimited Spotlight, the video portion to Visibility Unlimited. I'm Leslie Short, your host and the owner of Cavu Group. Today, our topic is kind of going to be on, who's going to stop me? But it's not in the way that you think it's going to be. I welcome my guest and friend and colleague, Nance Schick. Did I say it correctly, Nancy?
It's chic, but close enough.
Chick like chic.
That's exactly what it translates as in German, but I don't know that I'm the most chic person.
No, I'll take that. Thank you. Nancy is an employment attorney. She is a mediator, and she's very familiar with working within the DEI space. So part of our conversation today will cross over into that, but she's really here as an employment attorney, and we're getting to some mediation things. Nancy, welcome.
Thank you. It's so good to be with you. I wish I were in person with you, but I'll take this.
I know. We will connect soon again in person.
Yes.
We were having this conversation as we were catching up a few weeks ago, and the world was exploding in so many different ways. But when we look at the work arena, the business arena, the employee employer, we could be on 20 topics. But I want to start on the topic today about NDAs. And I think people get confused on what is going on with these NDAs and what you can, like people are like, all NDAs are gone. And I'm the person that's like, no, all NDAs aren't gone. There has to be a portion of the NDA that says ABCD that has to go. Can you share what's really happening?
Yeah, so it's so interesting because I just had a very similar conversation with my best friend who said, "Oh yeah, I saw that, no more NDAs." And I said, "Well, that's not at all what's going on." And so I said, and I love her. I can say that to her. We've been friends since we were 11 or 12. But what the Federal Trade Commission did is they banned most non-competition agreements, and people kind of collapse the NDA because typically that's the way we referred to the one document that
Right.
said non-disclosure agreement, confidentiality, and non-competition. And a lot of times that was put in one separate document, especially if you didn't have an employment contract, for example, because you weren't a high-level employee at your particular employment situation. But that one document, you're absolutely right, Leslie, that the only thing that's being carved out of that is the non-competition. And there's some public policy behind that. The two big issues that the FTC is trying to address is obviously non-competition is bad for the economy, right? We want people to be out there innovating. And if everybody is locking down the new ideas and taking the competition out of the marketplace, well, that's not a free market economy, right? And it keeps the general public from having good products and services. So that's the first issue it's addressing. But the big issue it's addressing is we don't want people who want to be able to work. We want them to be able to find gainful employment. We don't want them on unemployment for an extra 6 months because they're under a non-competition agreement when they want to be out there working.
So it's funny because years ago, I was hired for a company, and again, everything was in one document. And I think really at that time, we just didn't expect agencies to read everything. Maybe, I don't know, but I'm that geek person that loves contracts, and I love going through them.
And
And
that's wise of you.
as though I am not an attorney, I will sit and go through a 100-page document and circle and ask questions. And they gave this to me, and I went back to the attorney and I said, "You do realize I'm a small business. And if you want me to sign this, then will you pay me for the 8 months to the 12 months that you've stipulated that I cannot work for for the competitors, as much as you all let people, your executives, come and go and they go to the next competitor and they bring the agencies with them. We just know that's the reality of what it is. And he looked at me and I said, so unless you're prepared to pay me, then I will not be signing this, which, was a big stir because who tells a big company they're not signing something?
Right.
And they end up taking it out, that portion out, even then, because they realized it just did not make sense. But then how do you protect yourself? Even say small business, when you're bringing people in to work with you, you have everything else covered. The confidentiality, all of that's there. But how do you trust someone's not going to go give your coding special secret sauce away?
Well, I think one of the first things you got to think about is the access that you're giving people, right? And we do it on a need to know basis, right? And working in the DEI spaces and the confidentiality spaces that I work with on a regular basis, it's a good habit to start getting into, not just because of this issue with the non-competition, but almost everything we're doing is online, right? So you are connecting to the internet, which puts all your files at risk, which means a cyber attack is much more likely the greater access you're giving to some of this information. So what we're really talking to our clients about is narrow that access to only people that are using it, and use all those tools. If you're sharing electronic files, give a limited access for a limited period to only somebody that needs it, and then you lock it right back down. Right. And if you think about it, it's like we used to do, like, I always like to think of the analog version of everything, right?
Right.
So it's just like if you had a highly confidential file, you put it in your file cabinet, you locked that file cabinet, you took that key with you. And that's one way to protect yourself.
But that's not, let's be honest, that's not really the reality. Hire someone, they're on this project. I just had to call a client the other day, a year later, and say, can you please remove your files? Give me access to remove the files from my computer. Like, I'm no longer working with you and I no longer need access to this. Can you please take me out of the executive suite? It's been over a year and I'm still in there now. I didn't want to do anything other than save my own space, not to have to buy extra space. But if I was someone that wanted to, that was a full year that was there. And I think that people don't think about that. And so, and let's be honest, if you're at a bigger company, right? And those people have access, it's because they need it.
Yeah.
And you're not going to lock and unlock and lock and unlock. And so, though I don't want that clause in there either, I'm worried, is there another way to write something where you're not going to go tell the top secrets?
So, well, this is where we get now into the non-disclosure and the non-solicitation portions of that NDA, right? That document we call NDA or non-compete, and lump them all together. So now we're parsing them out, right? And we're taking them apart. So this is where you can still bind people to the non-disclosure. Now, the challenge with that is you have to get into what is confidential information, what is protectable. And that is something I look, even for myself, I have to consult an intellectual property attorney because I know enough to recognize the issues, but probably do not trust myself to know all the nuances around IP. So that's the first thing, is you list everything in that agreement. It's like, you can't have anything.
Right. No, because
and you hope nobody realizes that, right? But it might be in your best interest to actually look at what you have that's protectable. Because this is the other thing. A lot of people are like, well, that's my idea and you can't take my idea. But the idea is not protectable anyway. It's not until you actually do something tangible with that idea that it becomes protectable.
And if it's written in your agreement as a freelancer, as an independent contractor, because this is what this is all about, really, is that if you're doing the work for them, for a client, them being the client, it becomes their property. and cents. And that is usually written in, and that's where the shaky part is, because it's my idea. Let's say when I was producing events, the product is theirs, the concept of how to bring this product alive is mine. But yet, in some sense, once I hand it over to them, I can't go back and tell them you can never do this event again, unless it was a clause that was in there saying anything I create for you is mine. But then why are they paying me?
Right. And oh, you hit on a couple of big things for me. I'm going to start with the exactly what you're talking about with the handoff of and having the agreement clear on where the handoff is, what you still have rights to use, what they still have rights to use. And this is where an IP attorney can also help with framing it as a license, right? So that either of you or both of you have the right to use it in certain ways, and you can work around that so that it's very, very clear on what happens once the creation is done.
Right.
But you hit on something else that I figured we'd get into, and this is a hot issue for me, is independent contractor. So this is what we're talking about, right? And this is one of the issues that I have with this particular ban on non-competes is the FTC actually included independent contractors in the ban. Now, I can understand why you would have a ban on non-competition for employees. That makes complete sense to me. We do not want someone who, again, would otherwise end up on unemployment, unable to work because of something in a contract by someone who was in a much higher position of power and authority. So that all makes complete sense to me. I feel like the FTC got this wrong where the independent contractors are concerned, because an independent contractor is, when it's a true independent contractor, that's an independent business, right?
Yes.
With contracts, multiple contracts to perform their services.
And sometimes within the same field. Most people are in the same field. I mean, you know, I'm blessed enough to work in different segments, but a lot of people are in the same industry or field. So now they can't go work down the street next door.
Well, that's where it, you know, I think it's a challenge, right? Because as a business owner, if we're again having this free market, right? Then business owner, you're deemed savvy enough to negotiate your own contract. So when the FTC came in and said, okay, we're going to apply this ban to independent contractors, it basically said, well, some business owners are not savvy enough. The small ones are not savvy enough to negotiate on their own. That's not true. Really, what they're trying to do is protect the people that have been misclassified. So in my opinion, hey, maybe deal with the misclassification issue instead of creating this whole new category that bans non-competes for business to business transactions.
Yeah, because I mean, who it's end up hurting is the smaller business again.
Right.
Or that smaller business agency that's working, whether they're working with a small business or a bigger business. And so there's a fine gray line that I think if you are listening and you are a small business, that you are a creative, that or independent contractor, regardless of the field, that you really need to go through your contracts, your agreements, and make sure that that is not part of it.
Right.
Right. And to have that conversation is needed. I know sometimes everyone's looking like, oh my God, I got a gig, I got a gig, I got a gig. I'm so happy I'm working, that you kind of breeze through the agreements or contracts. And this is, again, different for independent contracts as we're speaking about employees that 9 out of 10 in most states are at-will employees, you know, which I think is also confusing as well. And once we finish speaking about that, I'd love to have that conversation just for a moment, what their rights look like, and absolutely what the EEOC is and who they are and what the advantage of working with them, and yet how they're making rules.
Yeah.
You know, so at-will employee, that everyone signs those agreements and signs the NDAs and everything else.
Right. So
Break it down. What an at-will employee?
So pretty simple. If you don't have an employment agreement that gives a specified term. So that happens, for example, I worked in sport. It was not unusual to contract with someone for an entire season, right? And you would want them to fulfill that entire season, especially if it's a coach, for example, or a marquee player. You have a specific term, or you as a dancer, right? You probably had a very specific term that said you're going to stay with us for this entire season. And if not, there may be financial penalties, right? That's a typical employment contract that changes the at-will provision. So unless you have something like that, and mind you, even if you have that, you may want to check and make sure it's valid, right?
Right.
Right, because it might not be enforceable. Like if you're a receptionist, they can't really bind you to a 1-year contract, right?
But they
In
will
most
say
cases.
you're an at-will employee and that they can fire you at will. So
Right.
they do that.
But what I'm saying is they
They
can't
can't
bind
fire.
you to like, oh, you have to work for a year or will, because that's not at will. And so a contract changes the at will relationship. So what the at will relationship is, you can either leave at will or they can fire you at will.
Right.
With one major exception with the firing is they cannot fire you for a discriminatory reason, right? And that's where these get very, very sticky, right? So hopefully that answered your question about what's the difference between at will and somebody who's under a particular contract that takes them out of an at will situation.
Right. So break it down for anyone that, if I confused you. Contract, you're working from here to here, boom. At will, you come in, you come out. We come in, we come out. We can fire you, you can leave, and that's it.
Yep.
But again, they can't fire you on retaliation.
Right.
And they can't fire you for any of the protected classes,
Right.
discrimination, that type.
Right.
And what happens, and this is where we're kind of blend that.
Yeah.
And I don't know if you've mediated with the EEOC before, but I have done a couple federal mediations. And people will call and say, I want to sue my employee. And I'm like, well, do you really? What's happening? What do you say? What are the options for people when they leave? And let's talk about, okay, so there's that. What's options? And I'm going to throw something in. What happens when people are getting fired online and they're videoing? And I don't know if you know that answer, but that is a big case that's starting to rumble. So let's talk about the EEOC first and then.
Okay.
Right.
So first of all, you want to know what's the process if somebody wants to file an EEO claim? Is that what you're?
Well, yeah. So if you feel that you have been discriminated against or fired for retaliation, what are people's options? Do they just go immediately and hire an employee attorney? Like, what's some of the options employees have?
Yeah, so there are a couple of things that I work with people on. So definitely been doing a lot more of this year because we've seen the mass layoffs. And so the first thing is, if you're part of a layoff or you're being terminated, if you're in a large corporation, they're often going to give you a severance agreement, right? Now, the first thing you need to know there is severance agreements and severance pay are not mandated. Their employers are not required to give, and people are sometimes surprised by that, right? But they don't have to give you anything. So in that situation, what the employer is usually doing is kind of buying you out. We all know there's a case right now about hush money in the news. It's kind of a similar thing where they're saying, we're going to give you some money proactively, preemptively to basically buy you out of any of the claims that you have. So first of all, that is not always valid either. You can't waive all claims, right? So this is why when you get a severance agreement, usually we'll contact an employment attorney to go through it with you and make sure that there is no discrimination there. If there is, what we often will do is I ask, again, I've been doing a lot of these this year, is I ask the client, what's your end game? You know, are you, in a lot of those times you're being let go and you're just thinking, I need enough pay to get me to my next job.
Right.
Even though I was discriminated against. That was my case too, right?
Right. But there's twofold, because I don't want to confuse people, because
Right.
there's a lot of layoffs that are happening with companies that are laid off and it has nothing to do with discrimination, and
Right.
they're receiving severance pay as part of, we are laying off these departments, and like I said, they don't have to give it, but here's 2 months, 3 months, whatever it is that they choose, and they have you sign off on that, and everybody goes their separate ways. That's different if you went to them and say, hey, I have a claim against you, or I'm going to file a claim against you for whatever, sexism, racism, all the isms, and you come to an agreement for severance pay.
Right.
Those are two very different ways that severance pays
Yeah.
are used. So I just want to be clear, because I don't want everyone to think you only get a severance if something is wrong.
Yeah, you're right. Here's the thing that I'm seeing is it's much more common
Yes.
that's when you're going to get it. And I've written about this a few times that, you know, in a severance situation, whether you're getting it because you're being terminated under a disciplinary issue or a layoff.
Right.
Either way, it's all about the leverage that you have that gives you the ability to ask for more severance pay or any severance pay, right? And the reason this is relevant is that it's absolutely the employer buying off your claim, right? They're basically saying preemptively, any kind of claim you have, we're going to give you some money, and then you're going to sign this agreement, and you're effectively waiving your rights to file anything with the EEOC, or in New York, if you're in New York City, you could also file with the city, you could also file with the state. So that's why the severance agreement becomes very important in this situation, is because, again, the employers are not required to give you severance at all. And the reason they're doing it is they're trying to minimize these unknown claims that come out of the woodwork that they didn't know anything about.
Right.
And then they just are trying to move forward, just like you are. So the great thing about knowing that is, you know, you can go in and say, we both want to move forward. Let's talk about the potential claim I have. I don't necessarily want to take you to court, but if that's what I have to do to resolve this issue, I'm willing to. And that's usually when they'll cough up a little bit of money.
Right. But then, like you said, they have the option to go to the city, they have the option to go to the state, and then the EEOC. Explain to people what the EEOC is that may not really understand. I think people hear it sometimes,
Right.
but don't know really their purpose or how they can be beneficial in situations.
Yeah, so the Equal Employment Opportunity Commission is a federal agency. So it functions very similar to the New York State Division of Human Rights and the New York City Commission on Human Rights, with a couple of exceptions. Usually the EEOC, especially because New York City and state have very, very strong agencies to handle the claims of their particular citizens. A lot of times the EEOC is going to say you need to go to one of your local. And there are different statutes of limitations. This could be a whole master class, right? Which we're not going to get into, because you just know that there are different deadlines. There's a different requirement for exhausting administrative remedies, which means that the EEOC, if for example, you contact them the day you get your termination notice, then they may tell you, go back to your employer and see what you can work out. They may tell you to ask for severance pay. They may tell you to notify them formally of the complaint if you haven't done so yet, right? There are some things like that. That's the other reason I say a lot of times you want to just go ahead and get the consultation with an attorney. There are plenty of us out there that will do things a consultation and guide you. And it's not going to be, we're not going to take your house in a retainer and keep you from eating.
Right.
Right.
Right. And I know, when I did the EEOC case, it was a mediation.
Mhm.
And I think a lot of times they would prefer you did a mediation as opposed to go to court. And not to tell the company that it was, but it was a young woman that felt there was a lot of racial discrimination and gender discrimination within this company. And, she came with her attorney, the company reps came, their attorneys. I was part of the mediation team on that. Bought in, one, I'm a certified mediator, as you are, but also bought in because of my DEI background to have a sensibility for both sides. I'm not, when I'm mediating, I'm not for one or the other. I'm for, can we come to some type of solution that all parties walk away with and are satisfied? And so I think mediation is also a great option,
Mhm.
uh, depending on the situation. And sometimes that may be speaking to someone like yourself and colleagues. And, the EEOC has a very strong mediation team, and
They do. And one of the things that I've been trying to educate people more about is you, if for example, in that situation, the EEOC is not going to refer it for mediation until there's been a formal complaint,
right,
right?
right,
So this is where I try to remind people that you can request mediation at any stage of a conflict. Now, there are some challenges for example, with employers may not be willing to do that because they're, they have certain budgets for certain things, and sometimes they need to attach their insurance policy to get fees paid for. And
right.
so sometimes they will request that a formal complaint be filed before they're willing
You can do
to,
something.
to
Right.
do any kind of formal mediation. But I am finding that more and more employers are willing to have these mediations or informal resolution conversations. Don't get too hung up on the label.
Right.
And so, it's the same thing. What we do as mediators is we try to get the parties to come together to create a solution, versus if you go to the EEOC, you go to the Commission on Human Rights or the Division on Human Rights, depending on which agency you've selected, you're basically deferring to someone else. So as a mediator, we're facilitating the conversation, right? I'm preaching to the choir here.
Yeah.
But for those of you that don't know that, that's what Leslie and I do when we're mediating, is we try to move the conversation in positive directions. It's a very different process than if you're in court and you're talking about what happened and who gets punished. We're future focused in that environment, right? And so it's very different from court. And I think people just forget that they could ask for that particular process, and it's so much better than deferring to somebody in most cases. And more than 80% of cases settle without going all the way to trial, which suggests to me that this probably would be
Right.
more beneficial. Right? So that being said, is you have to think about that. Do you want more control over the outcome? If you do, then going to an outside agency to tell you what you deserve and who was right and wrong is probably not going to get you the result you want. It takes a little more intellectual work, a little bit of emotional work, right? Or maybe a lot of it, depending on how heated the issue is. But in the long run, you build skills while you're in there, and you get to create the solution in a way that you just feel a little more complete with a mediation. So that's always available. And that's something that I've been trying to remind people, is you don't have to wait. You don't have to wait
Right.
to have a conversation.
Absolutely. But people should know this is going to take time. It takes time to put a complaint in, and things aren't going to happen overnight. Your severance may be out by the time you actually get to go in. So to be aware, mediation may happen quicker, but that, like all of this, is a process. And for those that are listening and watching, I know you hear us speaking about New York. The EEOC is across the United States. There is one in every single state. Mediation is across the board as well. We just happen to be speaking about New York, but I'll throw in another state so everyone doesn't think it's one-sided. California just changed their work laws as well for 10 or more employees on discrimination. How you have to report that is, if you are a company that has 10 or more employees, there is a new discrimination law that's out, and how you handle that. So there are things across the individual states that are really looking at how to protect employees at this point, and as well as as protecting the employer. It does go both ways. The new law for the LGBTQ plus, that in workplaces, where was this? The bathroom, the EEOC just came across this. I don't know if you saw this. I think this came across today, where there has to be gender neutral restrooms. And for some of the companies that I work with, I'm like, assign one. If you have, some just have, I hate to say it, male, female labeled, and there's always that guest one. Make that gender neutral. If you have someone that comes and visit and they're not comfortable, you have someone walk them to where they are comfortable. I think it's a point now how we have to figure out how we work together so that these cases of discrimination and all the isms, I hate to say, I would like to say decrease, have conversations before they're filed, all those things. I want to get back to the video recording, because I don't know if you know about this one. If not, we can chat, and I'd love your thoughts. I guess about 3 months ago, there was mass layoffs, again, over Zoom. Now, we've heard all the old ones about Zoom and put everybody in a room and then cut the chat off and boom, and that's it. Well, this person kind of felt it in their gut that they were going to be let go. Meanwhile, their own personal texts and everything was going, so people knew what was happening. And she decided to record as she was being let go. But then there was a lot of attorneys that said she could actually get in trouble for recording because the employee didn't know, that person did not know she was recording them. Thoughts on that, please?
So this all falls under state law, right? So depending on the state that you were in when you did the recording, and possibly the state, because this is the world we're in now, right? Where your employer might be in another state. You need a privacy attorney that can probably help you navigate the laws in both of those states, because that is definitely a state law that is triggered. And so, for example, I believe this is one of the issues in Michael Cohen's case, right, where in the Trump cases, he had recorded some things one-sided, and in New York, it's a one-party state. So basically, you can record whoever you want with or without their consent.
Okay, then I'm gonna throw something in, and I know you're not an AI expert,
right?
but I want to throw this in, maybe from a legal standpoint, which I know is also very cloudy with the attorneys right now with this as well. We've been joining these Zoom meetings, and something AI pops up, and they usually join the meeting before the person. And I'm taking notes for blah, blah, blah. 9 out of 10 will not let them into the room. Mm-hmm. And I do that because no one's asked, can I record this or take the notes for this in advance? Now, I've had one person that sent an email in advance and said, I would like to use my AI assistant to take notes. Push yes or no.
And that is another perfect example of the challenges that we are facing. There's a lot of opportunity with AI, but these are some of the issues too. And on the attorney end, absolutely, the privacy confidentiality is a concern. Mm-hmm. When you have a bot taking notes and you have no idea, but knowing how AI works, and without getting into a masterclass on that, because we can go down the rabbit hole in so many ways, is then basically the way AI works, right, is it's taking that, so those notes, and depending on the terms of service for that particular bot that's taking notes for you, they may or may not be reusing it to train the bot on the, you know, and have a new model. So
Right.
imagine, for example, I'm doing that with a client, which, by the way, there's no way I'm going to do that with a client, right?
Right.
And but some people do. Coaches do this, for example, right? And I've talked to them about, I don't know if that's a great idea. And so they'll have the bot that comes in the chat. And I said, no, not doing it, right? Because we might talk about something. But let's say if it is an attorney, and I'm doing that, and now the bot is taking confidential information, attorney-client privileged confidential information, and using it to train its data. I've now violated my ethical responsibilities to the client and potentially put their highly sensitive confidential information out there. That's, even though it may never be reassembled, this is definitely a challenge for anybody that's using that kind of tool.
So for any employee that, you know, is using that to try to get back at their bosses or work or reporting, be aware that it could work in your disadvantage.
Yeah.
Yeah.
And here's what I would recommend instead, and I recommend this to anybody, if the moment you take a job, it's like you should have a folder that you start putting things in, you know, just like you put your employee handbook and everything, and you start a log,
Nancy.
right?
I agree with you, but that's showing our age, because I worked with someone a couple weeks ago, different generation, and she was just like, no, I need my notes, or I'm not going to know what I need to turn back in after. And I said, well, I'm going to challenge you to work a different way today. And I'm going to work with your notes. We're going to challenge each other, because if the only way you can go is working by these notes, then I feel like you're still missing something. And maybe I'm wrong. Maybe I've yelled at people about taking notes when I do speaking engagements and they're writing everything down. I'm like, well, you're not focusing then. So it's a double-edged sword. There's a purpose for it. And I think it's just a matter of, what do we always go back to on all of this? Whether it's an NDA or you have to communicate with people.
Yeah, I think you're right. And so whether you're taking notes by hand, you're typing them, again, caveat with the AI bot, definitely think there are some issues there. But I definitely feel like it's always a good idea to make a couple of notes of what those key points are. And if you look at business processes, this has been built in forever. That's what, and it used to annoy the heck out of me when I was starting out, right? And then you'd get this email back that says summarizing the key points of our meeting, and you're thinking, I was there, why do I need this? Right. But likewise, I've now seen the flip side of that, where the taking verbatim notes, people can't then necessarily synthesize what the key points are, and everything seems important. And I think we can see this in our internet generation, right? And this information age that we're still in at high speed. So I still say you always take a few of the key points down when if, for example, you're now in this meeting and you know you're about to get terminated, as soon as that meeting is over, if you haven't been jotting just a few key words and some quotes of what was said, sit down, make that note right away, right? And what we need is a log, right? And the reason I'm telling people this is because we may need to use it in your case if you have to file a case. It also can help if you go back to your employer and say, on this date at this time in this meeting, these people were present, they heard it, and here's what was said, and that was discriminatory. And now you're letting me go, which is retaliatory. Boom, it's a lot harder. You may not have the exact verbatim recording, but you have enough circumstantial evidence to support that that probably happened. And we've been dealing with that and imperfect evidence my entire career, and we
Right.
still somehow manage to get it right most of the time. Obviously, we don't get it right 100% of the time, but no one does. Not an excuse.
Documentation.
Not an excuse, doesn't mean we don't still strive for perfection,
Right.
but don't get so hung up on it only being one way. We can still work with evidence in other ways and put your story together.
Right. So as to, because we can go on all day, of course,
We
but
could.
I guess to do a closure on this as an employment attorney, what are the top, I'm putting you on the spot now, maybe the top 3 things people should know, whether it's the NDAs, whether it's the at-will employee, whether it's recording. I mean, you gave a lot of good tips on what to do, but what's the top 3 things? And maybe from the employer standpoint as well, so that they don't have these cases. I don't want this to be a one-sided conversation, but there's so much happening and laws are changing quickly state by state in favor of the employee. But knowledge is power, and reading through documents that's coming out in the news, 9 out of 10, most people aren't going to sit there and do that.
Yeah.
So,
So first thing is start thinking about whether you're an employee or an employer. Start thinking about, how do I build this as a partnership, not a legal partnership. You're not going to go file a document and call it a partnership. You're not going to own the company anymore, but really looking at the mutual benefit that you all are coming together for, right? The mutual goals that you're trying to achieve. I think when you start shifting your mindset around what the employment relationship is, that starts to create a different experience for both parties, right? So that's my number one thing is start thinking about work differently and think about it as mutual benefit. How that flows into other areas of your life is you start to go, oh, I'm having a struggle with my employer. And this is what we would do in a mediation setting, right? What is it that they're probably needing that they're not getting? And what is it that I'm needing that I'm not getting? Because all it is that, right? And then you talk about, how do we get what we need, right? So I think that's the first thing, is you change the way you're looking at employment.
I'm going to throw something in. If you
Yeah.
build an inclusive culture of one that has equitable communication, part of that they will know where to go and who to speak to. Sorry,
Right.
go ahead.
No, that's wonderful, because that's part of the conversation, right? An
Right.
inclusive culture is one that recognizes everybody's coming together, right? It's all this talk about team for all these years. Look, I've played sports most of my life, and I've played a lot of team sports. There are, I would say, a large percentage, I won't give a number, but a large percentage of the organizations that use team and family and all that stuff are not living up to that, right? Because they're not valuing every single person in their organization
As a person and not a number. Yes.
right? And recognizing the contribution. So that's where it all comes together. But I hear it from employees too, right? So I hear it in both directions. It's one of the assignments I often give, is you all both sit down and list 10 things that you think the other one contributes to your workplace. Changes the conversation, right?
It does.
So that's the first thing, is like, start thinking differently about it. If you're an employer, yeah, you've got a lot that's coming at you right now. And if you're not aware of it, now might be a time to reach out to your employment attorney if you have one, or start developing a relationship with one in not just your primary jurisdiction, but anywhere where you have a worker. Because you may have some misclassified workers who are employees, which means employment law in Utah might be applying for you in New York, and you don't even know it yet.
Right.
So that's one thing, is you got to just get an attorney to just help you kind of wrangle all of this in, because it is so much with the FTC, the NLRB, New York State, right? I can go on and on, right?
All the initials, and then add
we
Zoom
have-
into the mix with everybody all over the place. Like you said, all the different states, it changes.
Yeah. And if you're an employee, I would say the other thing is start keeping a log. I can guarantee your employer has one on you. So one of the things, and this is, I say that with the caveat of, you still want to be working toward that partnership relationship, the mutual benefit, the peaceful relationship, but it never hurts to CYA. Because you never know where you're going to need it. And you might not need it for that purpose, but it might be that you go, oh, actually, that's not being represented exactly the way that's going to narrow down what the issue is that's solvable. Because that's what we always want to do, is we always want to not necessarily bring everything into the conflict. Your feelings about it are valid. As mediators, we let you feel them, we help you through it. But at the end of the day, we need to narrow down what is the issue that we can solve, because can't solve the past, can't solve certain things, but let's talk about what we can solve and let's start moving in that direction. And that log of something doesn't feel right, here's what happened, etc., gives you something to refer back to, and then you can start to, again, focus on what's the issue that needs to be solved, so that when you go back to your employer to say, I think I'm dealing with a hostile work environment because I'm in this protected class or that protected class.
Right.
Or hey, I'm a bystander of this, and I've been witnessing this happening to one of my coworkers. Because, you know, that's something I've said recently too, is all the training that we do for anti-discrimination and sexual harassment prevention. I think people have had in their mind that, oh, we do the training, and then the people that need to hear it are the ones that are going to go, oh, I didn't know I was doing that wrong.
No, they're absolutely the ones that's not hearing.
Exactly. The training is for the bystanders.
Right.
That's who benefits the most, is
Agreed.
recognizing, oh, this is what I do when I witness it. Because if
This
you're
is what I've been seeing.
If you're the target, a lot of times you're too traumatized by it. So we need the bystanders to speak up.
Right. Love that. Nancy, thank you so much. I think I'm changing the title of this from Who's Going to Tell Me No to A Conversation with an Employment Attorney. You gave us so many different great nuggets on so many different topics that are happening as the workplace is moving so quickly. It's not going to ever be what it was before the pandemic. I know we say that. It's not what it is after the pandemic, is what we're trying to make it now. I think people are much more educated. Employers are much more educated on options and the way that they can and want to work, how we want to work together. And so I appreciate you breaking down a lot of things that we hear in the news, but may not have had the opportunity to really understand it. Where can people find you if they would like to have a better understanding, or a consultant with you, or hire you?
So it's pretty easy. My business is Third Ear Conflict Resolution. So if you go to thirdearcr.com, you'll find me. Wonderful. I'm also on LinkedIn. I'm now on Instagram. Finally. Let's see. So LinkedIn, Instagram, Facebook. It's almost embarrassing to admit that at this point. And YouTube. Yeah.
Wonderful. Well, I will make sure everyone has all of those contacts as well. Again, Nancy, thank you. It's been lovely speaking with you. I enjoyed it. A lot of tips. I hope everyone else enjoys it as well. I look forward to seeing you soon.
Thanks.
Everyone, please continue to listen and to watch Visibility Unlimited and Visibility Unlimited Spotlight. As always, I say thank you. I look forward to you joining us again. Take care. Bye now.